Now, in relation to ISDS, are you aware of concerns that have been expressed by the Chief Justice of the High Court of Australia, the Productivity Commission, Professor Joseph Stiglitz, Nobel laureate, the UN Special Rapporteur on Trade, who've said that these are not appropriate for trade agreements. They should not be included. Are you aware of those concerns?
Yes, we're aware.
Okay, and so are they misguided, or are you saying there's been such a change in the ISDS mechanism in the TPP that it's not like any of the others?
We have listened very closely to the range of views expressed about ISDS, and we've worked through those concerns in trying to formulate the best ISDS mechanisms that we possibly can in the TPP. Okay,
so can you explain what those mechanisms are that are improved? So can I ask you, for instance, is the new regime going to include independent judges making the decisions rather than corporate lawyers who can 1 month act for a multinational and the next month sit as an arbitrator?
So there are a number of procedural concerns that have been raised, including by Chief Justice French. Mm-hmm. One of those issues does go to the arbitrators. Mm-hmm. So we are aware of this. Obviously, this is a much larger issue than just the TPP, but we've thought about this very carefully. Yes. And in the context of the TPP, the parties to dispute do get a significant degree of control over the appointment of arbitrators. So each party appoints its own arbitrator, and then the third party is to be jointly agreed. And if the third party can't be jointly agreed, then there's an independent mechanism for the third arbitrator to be appointed by the Secretary General of the International Centre for Settlement of Investment Disputes.
They can still be corporate lawyers, though. They don't have to be independent judges.
I might ask.
They can still be lawyers who are multinational corporation lawyers in their regular day job.
Well, that is correct, but as Ms Ward has said, there is significant control in the TPP that the parties have over the appointment of arbitrators, because we get to choose an arbitrator and we get consulted and need to agree on the presiding arbitrator. So for that reason, I think this is an improvement on previous models. There's also a requirement for arbitrators to comply with rules on independence and impartiality, including to address conflicts of interest issues. And in addition, there's a placeholder in the TPP in relation to appeals. So should an international court be developed to deal with ISDS disputes, and this is under discussion, as you may know, in the context of the EU-US FTA negotiations, then TPP parties will consider whether that appeal mechanism should apply in the TPP.
And will the ISDS process apply precedent?
No international law applies a strict form of precedent as exists in common law systems.
If I could just break it, see if we have a division, so we'll have to suspend until after the division.
Okay.